So the suspect accused of a second assassination attempt on former President Donald Trump is indeed staying behind bars. Federal prosecutors at a hearing today argued to keep him detained while they pursue their case. They presented some new evidence at a court filing, including a letter this guy Ryan Ruth had written months ago declaring his intention to kill the former president. Misty Marris, trial attorney, legal analyst, joins us now. Hey, Misty, so, I mean, literally, it says this was an assassination attempt on Donald Trump, but I failed you. I guess he dropped it off with somebody, so there you go in terms of motive.
Oh, yeah, absolutely. And so we saw a lot of this in the prosecution's detention memo, because that's what today was all about, whether or not he was going to be held pending ultimately a trial on these two gun-related charges. No surprise, prosecutors in that hearing said that there are going to be more charges coming down the pike. And so what we heard in that detention hearing, though, really relates to the two pillars of what a judge considers when holding somebody. Are they a threat? Are they a danger? And are they a flight risk? And what we learned in that detention memo, he had passport, travel documents, directions to Mexico from Mar-a-Lago. And then as far as being a danger, we learned that it seems that the allegation is going to be that he'd been planning this for quite a long time. He was there for 12 hours before. Obviously, he fled law enforcement and also a host of other information from that very chilling letter.
It was a chilling letter. He's, passing it on. He had failed. He was, passing it on to someone else, I suppose. The gun charges, let's put up his charges. Possession of a firearm by a convicted felon, possession of a firearm with an obliterated serial number. We've been hearing about this for some time now. Obviously, additional charges is where this is going. Is any obstacles to that, or now it makes it easier today?
It seems, especially to your point, well, he wrote it out, right, that this is an assassination attempt. So you're likely to see the charge of assassination, attempted assassination of a major political candidate.
Is that how it's worded? I was wondering about that because it's different than a president. He's not the sitting president, but that's how it's written.
Correct.
In
that's
law?
how it's written. That's another specific charge. The other charge that it could be is retaliation against a federal official and saying that he's a former president. He could fall into that bucket, meaning because of what he did while he was in political office, this person was retaliating against him. And then the other charge, and this is where you kind of look into these ties, these foreign charges. You see him referencing Iran, and was there anything to that? You could see something in furtherance of terrorism. That's another area, but that charge of assassination attempt of a major political candidate, that's what we're very likely to see when this indictment happens.
How difficult? I mean, the terrorism thing might be more difficult to bring together. It would be, you think? Yeah. Whereas the assassination, you have the word in the letter.
Right. So, and remember, Connell, we talked about this before. Just because you fail at what you tried to do doesn't necessarily mean that you can't be convicted of it. You don't get off the hook. So you're going to look at all of that evidence that they have, and a jury would be asked to make a determination. Was this an assassination attempt? And putting all of that together, coupled with his own writings, that's how you're going to get there with that intent aspect of the case. Basically, what it requires when you have an attempt crime, that you make the plan and then you take an overt act towards that plan.
But we always hear about federal officials, and usually it's the president. If someone, crazy person, writes a note or whatever it is, oh, they were threatening the president at the time, or a former president, I guess, or is it different? And does it have to be to kill them or some sort of a threat? Because I've heard, you hear stories, Secret Service will show up on your door if you, quote unquote, threaten the president.
Absolutely.
That's the sitting president, though. How does the law work in these cases?
Correct. So you would still have laws that would cover somebody who's a former president or who's a candidate. It just is different than the laws relating to the actual president of the United States or someone who's sitting as a public official.
Because that's a federal crime, right? To make a threat towards the sitting president of the United States.
Correct. But you could also, to the extent that for some reason somebody doesn't fall under that bucket, there's state-level crimes that could apply as well. And that's why you hear we're not talking about attempted murder. We're not talking about that because that would fall under state jurisdiction, and we're talking about the crimes that fall under the federal umbrella.
Quick thought on another case. It broke at our last hour. We had the verdict live from Boulder, Colorado, the supermarket shooting. I think there were 55 counts, guilty on all 55 from back in 2021. Your thoughts on this case? There's the guilty man. So
it was never in contention whether or not he pulled the trigger. The question was, is he not guilty by reason of insanity? And in Colorado, the standard is you don't know the difference between right and wrong. What came out during the trial? Well, that there was a lot of planning, a lot of preparation, scouting location, buying a bulletproof vest to protect yourself, and also a really dramatic showing by prosecutors of how the effort it takes to reload that gun, and that he did that. And I think all of that
then
together
that becomes a tougher defense.
Becomes a way tougher defense. And when the jury was deliberating, because they didn't come to a determination on day one, right? They 5.5 hours, I believe, was the number at the end of the day.
Yes.
They asked to hear the information that was from one of the forensic psychologists who had testified. And so it was very clear that they were looking at what is he hearing and whether or not it's mental illness, which is not enough to be not guilty by reason of insanity. And clearly
By the way, I bet is that the only option the defense lawyers will have for this Ryan Ruth guy that we were just talking about as well?
I can imagine that we could absolutely see something relating to mental capacity. You know, today his lawyers argued, well, he's not he's a really bad assassin, and the judge said, that's not really going to be. But you're right, we could hear that defense again. Anytime you have that level of planning and preparation, to the extent the evidence supports what we're hearing preliminarily, it's a real hard sell.
Yep. Thank you, Misty, as always. Misty Marris with us now.